Hiring foreign employees in Vietnam is not as simple as extending a local employment offer. While the labor relationship may look similar on paper, the law treats it differently. Every foreign worker, whether a manager, expert, or technical specialist, must have both a valid work permit and a labor contract that aligns perfectly with it. Yet many foreign invested companies still use generic or global templates that fail to comply with Vietnam's labor code. The result is unenforceable agreements, invalid work permits, and serious compliance risks. Understanding the legal structure of foreign employee labor contracts is essential for every employer operating in Vietnam's globalized economy. The labor code set the framework for foreign employment in Vietnam. A foreigner can only work in Vietnam if they 1. Have a valid work permit or work permit exemption, 2. Sign a written labor contract in accordance with the permit, and 3. Perform the job stated in that permit. The labor contract must be signed after the work permit is issued and must mirror the job title, workplace, and duration listed in the permit. If the contract contains inconsistencies, for example, a longer term or different position, both the contract and the work permit may be deemed invalid. The main difference between contracts for foreign and local employees lies in the legal linkage with immigration and licensing procedures. A local employee's contract stands alone under the labor code, while a foreign employee's contract is tied directly to their work permit. This means the contract duration cannot exceed the validity of the permit, typically up to 2 years. Extensions require both a new permit and a new contract. Furthermore, the employer must register the contract with the local labor authority if requested. Another distinction lies in the language. Foreign employee contracts must be bilingual, in both Vietnamese and the common language, usually English. In case of inconsistency, the Vietnamese version prevails legally. Many foreign employers make avoidable mistakes when hiring expatriates in Vietnam. The first mistake is signing the labor contract before the work permit is issued. The second is using a generic international labor contract that does not reflect the permit details. Some companies also assign foreigners to different roles or work locations than those approved in the permit, which constitutes a violation. Another frequent issue is failing to notify labor authorities when the work permit or contract ends, which can result in compliance breaches. These errors can lead to administrative fines, permit revocation, and reputational damage. A compliant labor contract for a foreign employee must include all clauses required under Vietnamese law, including job title, workplace, duration, salary, benefits, working hours, and termination conditions. In addition, it must specify the foreign employee's nationality, passport number, and work permit reference information. Salary must be declared in Vietnamese dong for payroll, tax, and social insurance compliance, even if payment is made in a foreign currency. The contract should also address housing, relocation, and repatriation benefits if provided by the employer. Clear clauses on confidentiality, intellectual property, and tax obligations are strongly recommended. The work permit and labor contract operate as a single legal framework. The work permit defines who the employee is allowed to work for, in what position, and for how long. The labor contract defines the employment relationship and compensation. If either document conflicts with the other, the employment may be deemed illegal. For instance, if the contract's duration exceeds the permit, the employer must terminate the contract or risk penalties. When a work permit is renewed or extended, a new or updated labor contract must be signed to reflect the permit's validity. Maintaining consistency between the two documents is not just best practice, it is a legal requirement. Termination of a foreign employee's contract follows the same rules as for local employees: lawful reasons, statutory notice, and full settlement of benefits. However, when the work permit expires, is revoked, or the employee no longer qualifies, the contract automatically terminates. Employers must also handle exit procedures, returning the work permit, cancelling resident status, and completing final payroll and tax clearances. Failure to complete these steps can delay future applications or trigger penalties. LTS law recommends conducting an exit audit for foreign employees to ensure full compliance with both labor and immigration requirements. Under current regulations, foreign employees with valid work permits are required to participate in Vietnam's social insurance system, unless they are intra-company transferees or covered by a bilateral exemption. Employers must also withhold personal income tax based on total compensation, including salary, housing, and other taxable allowances. Labor contracts should clearly define tax obligations to avoid disputes. Many companies mistakenly assume foreign employees are exempt from social insurance, only to face back payments and penalties during audits. Proper contract drafting ensures transparency and compliance in payroll and taxation. LTS law provides comprehensive legal support for companies employing foreign nationals in Vietnam. Our team drafts and reviews bilingual labor contracts, aligns them with valid work permits, and ensures compliance with both labor and immigration law. We assist in filing or submitting labor contracts to authorities when required, renewing work permits, and conducting internal HR compliance audits. For FDI companies, we also harmonize global policies with Vietnam's regulatory framework, balancing corporate consistency and local legality. Our goal is to help employers hire, manage, and retain foreign staff confidently and lawfully. Hiring foreign employees can bring global expertise and business value, but it also brings compliance responsibilities. A single mismatch between the work permit and the labor contract can invalidate the employment relationship. Avoid unnecessary risk by ensuring every contract for foreign staff is bilingual, consistent with the work permit, and 100% compliant with Vietnamese law. Contact LTS Law today to review your foreign labor contracts, renew your work permits, and build a globally compliant HR framework in Vietnam. Stay legal, stay confident, and let LTS Law be your trusted employment law partner.